to start letting them in. Hi, everyone. Welcome in. We're going to give a second for everyone to get in. Please make sure your microphone and video are on mute for right now. We'll have some impromptu networking after, but for right now, please make sure you keep it off. And we're just going to give everybody a second to get in here, because if they're anything like me, they wait until the last second to sign in, because like, oh, I like snooze until 0 hours before start, and then it's like, ah. Dun, dun. For our lovely speakers. Everybody a second. Look, everybody, I didn't have to turn anybody's video off this time. These people are so good.
We're all getting used to it.
I know, right? It's
Yeah.
a change. It's a change. I miss seeing everyone's faces in person, though, that's for sure. Ah, there's my lovely president. Welcome in, welcome in. Dun, dun, dun. Hello.
Hey, Jennifer.
Oh, let me unmute you 1 second. Okay, I have unmuted you. Welcome, everyone. I'm just going to get everyone in, and then I'm going to disappear and let Jen take it over. And our lovely speakers. And our sponsors.
Yay, sponsors. Sponsor.
Whoop, whoop. Wendy, could you resend that message you sent to the chat? I don't think everyone saw it because they weren't allowed in yet.
Sure.
Thank you. Dun, dun, dun. Getting everybody in here. We're going to just let people in as we go. So if you see people coming in.
So do you want me to wait till everyone's in, Rach?
No, you can send the message.
Okay.
Okie dokie. Okay, Jen, are you good to go?
Yeah, I was reading Wendy's chat. So I know what's going on. Okay, well, welcome everybody to our third digital education program. We are so excited. I am Jennifer Richardson, your CAI California North Chapter 2020 president. What a weird year, right? We do have a few board members that I think we're going to be in attendance today. It's hard to tell because I can't see everybody's faces, but I will just give a shout out to all of our board members because they've been working so hard during this crazy time. John Hanson, Scott Hubbard, Mark Glassberg, Miranda Ward, Richard Navarez, Dan Young, and Jeff Brown. What an amazing team. They have spent a lot of time making sure that we are communicating with you guys during these crazy times. If you have any questions about the chapter, please feel free to reach out to any one of us or Rachel. Any one of us would be happy to help you out. We could not make any of this possible without our event and sustaining partners. So we want to give a special thank you to those partners who have donated their sponsorships for events that could not occur during 2020. So Rachel is sharing some of that information. And while she is, I will remind you guys to follow us on social media. We can be found on Facebook, Instagram, Twitter, YouTube, and LinkedIn. And I think Rachel has some information to share on that as well.
I will be posting all of those links to the chat for you so you can easily click and go like us.
Wonderful. Okay, normally during this time, we let our event sponsors have a couple of seconds to say hello. I'm not sure if we have anybody here today, Rachel?
Levon is here, representing Cagwin and Dorward.
Would you like to say a few words?
I would love to. So my name is Levon with Cagwin and Dorward. We're a landscape contractor. We're full service, specializing in maintenance, comprehensive water management, and tree care. We've been in business since 1955, so if we can help you in any way with any of your landscape needs, give me a call or email me. Thank you.
Thank you, Levon. Our other sponsors are Mastercraft Painting, and unfortunately they are not able to be here with us today, and Seacoast Commerce Bank, who we also do not have a representative from, but we still want to give them a big shout out and thank you for sponsoring our event. We appreciate you guys very much. Of course, our other rock stars are our registration sponsors, and today's registration sponsors are Badalin and Jacobson, Pacific Western Bank, and Social Insurance Agency. So thank you to all of our sponsors, and we ask that you guys please consider them when you are planning projects or need help in your communities. Okay, a little bit of housekeeping. We are recording this meeting, so it will be available for view on YouTube shortly after the program ends. We ask that you keep your microphone on mute and your video turned off for the program. We will be taking questions via the chat function. Wendy Benner will be moderating that and helping out the speakers with the questions. That's at the bottom of your screen. And anyone who misses seeing people, this is when you get to turn your cameras on. At the end of our event, we'll be doing an impromptu networking session. So you can turn on your microphone, you can turn on your video, and you can chit chat. So don't sign off right away. And now, on to the reason we're all here. Our program today is Advanced Risk Management. It's being presented by Allison Anderson of Angus and Terry and Julia Souza of Alliance Community Resources. So Allison and Julia, thank you very much for being here today, and I'll turn it over to you.
Thank you so much.
Yes, hi everybody.
Hi everyone.
I think Rachel was going to make an announcement that maybe she didn't make, so I'll just step in and make it. And that's that, we are definitely here for you today and are interested in hearing your thoughts and concerns and questions. But we are definitely not here today to provide you with any specific legal advice for your clients. You definitely should contact whatever attorney your client is working on if you have any specific problems. This is more a general presentation for your information.
Great.
Oh, there's the disclaimer Rachel just posted.
Good stuff. Well, we're super excited, Allison and I, to be presenting this today. This was a brainchild of ours last fall. We sat down and had lunch together and kind of wrote it down as an outline, and just really hope that you find it to be very helpful for you. Allison, thanks for your great work in putting this together, and Wendy as well. So here we go.
All right. So when I started law school, one of the first things that they try to teach young lawyers is that a successful lawyer is going to be the lawyer that can quickly spot legal issues as they come up. And of course, all of our industry trade organizations beat over the community managers' heads and the board members' heads that they should not be practicing law. And, of course, that is 100% true. But the reality is that the community managers and the board members, to some extent, are really on the front lines in this industry. And unfortunately, it does place pressure on the managers and on the board members to be able to spot what the important legal issues are and then make a decision about whether or not they warrant bringing an attorney in. And I think Julie is going to talk about that a little bit later in the presentation. But our hope today is that we can remind you of certain legal issues and things that should take precedence. I think that everybody is feeling a little bit overwhelmed by emails right now because everybody is communicating by email, and people are expecting to receive information and responses on a daily basis. And so it's hard sometimes to see the trees through the forest. So we hope that this presentation helps you with that.
Great. So, this first slide is a little basic, but it's something that we still feel is very, very important to review, right? The Community Association Law hierarchy. State statutes, including the Davis-Sterling Act, California Corporations Code, and of course the Davis-Sterling Act, unless it says, unless your governing documents state otherwise. Your CC&Rs, Articles of Incorporation, bylaws, and your operating rules, which are things like pool rules, your architectural guidelines, election rules, things like that. Remember, all of those are part of your governing documents. You don't get to pull one out or the other. They all become a part of what governs your association.
The funny thing about this year, of course, is that, or last year, of course, is that, you know, there's always an exception to every rule. And although the new election laws are placed in Davis Sterling and of course take precedence, the new election rules all say you have to go by what we have in these election rules and ignore your, you know, bylaws and your system to some extent. And so, you know, one important thing is absolutely that hierarchy is very important that you understand it. But what is also important is that every January you stay on top of what the new legislation is, because the new legislation can impact that hierarchy in some regards.
Right, right. And a good time to really start paying attention to that is now. Right now is when we're in legislation season. Even in the middle of a pandemic, our legislators are working on laws that affect homeowners associations. So stay engaged in that. Make sure that you look for your calls to action and read the documents that's being sent out and the videos by Louie and by Clack, so that you know exactly what's happening and that you can prepare accordingly, because now is the time to start preparing for laws that may change more immediately and some effective January 1st.
Okay, the Open Meeting Act. Why am I even raising this issue? It's been around so long. And we all know what the Open Meeting Act says. And I think that unfortunately, there is still a huge tendency to not follow what is required in the Open Meeting Act. I know the managers work really hard, but sometimes it's impossible to keep people from meeting, particularly if you're not on site. So why is the Open Meeting Act so hard to follow? It's not. It's not hard to follow. And every time we get new boards of directors, it's the first thing that we teach them so that they, you know, understand when they can meet and when they can make decisions. And the visceral response that you get from a good percentage of those owners is that you know, they don't want to actually deliberate in front of the membership because they're not comfortable with what their new job holds. And so they try to, you know, do what they can do in between the meetings with emails, with unauthorized meetings. And, you know, what that does is that prevents the association members from hearing the deliberations on important issues that affect them. And so I know the community managers try really hard to make sure that the Open Meeting Act is followed. And we want to make sure that it's being followed too. And if it is not being followed by a particular board and they need a coaching session, I'm sure the lawyer would be happy to get on the phone for 15 or 20 minutes. New boards don't often understand what can happen if they don't follow the Open Meeting Act. One other big issue that I see constantly, and it is because I have a substantial litigation practice, is that you know, the industry has moved towards having quarterly meetings and away from having monthly meetings. And what that has done is it's made it more important that the business get done only 4 times a year. And in a lot of communities, and in particular communities in litigation, 4 times a year just isn't enough. I understand that there's a financial component. I understand there's a time component. But if you are working with boards and you are watching them meet on a monthly basis when they're supposed to only be having quarterly meetings, it's time to consider whether or not they should go back to monthly meetings or even perhaps, you know, meetings every other month.
So we're going to talk a little bit more about the Open Meeting Act. Now, you all may have heard that Governor Newsom passed an emergency resolution earlier this year when the coronavirus really just started that suspended part of the Brown Act. The Brown Act is part of the Open Meeting Act. And I think a lot of people got a little comfortable. Oh, that's great. Well, the fact is the only thing that was suspended was the requirement that boards meet in person. So now boards can meet via video conference. Everything else still remains the same though, right? So we want to make sure that you are very, very careful about you know, posting agendas when you are supposed to post agendas, putting the items on there that are supposed to be on there, and not vague descriptions, but descriptions, right? We're going to review landscaping proposals. We're going to review not just contract reviews, but get a little bit more specific. You're required to do that. Meetings, you still have to have your board meetings, and you can have them via video conference these days, which is fantastic, right? I totally am loving this whole, you know, business on the top and shorts on the bottom, kind of having a little casual atmosphere at home. But we still do have to have our board meetings. And as Allison said, if your board's gotten a little lackadaisical about how often they meet, make sure that they're actually following their bylaws and they're taking care of business. One thing that I've noticed is that boards are meeting less frequently, but they're communicating and violating the Open Meeting Act more frequently. And so we need to bridge that gap. We need to get back to only conducting board business in a meeting. And then meeting minutes. I keep seeing the chats come up. Hi, everyone. Meeting minutes required by Civil Code that you take your meeting minutes, that they're available by review for review by homeowners within 30 days. We're going to talk about records request in just a little bit. And that your meeting minutes are descriptive into the actions of the board of directors. So again, make sure that all of these things are still being followed according to the Davis-Sterling Act, because you are not allowed to, or you should not, move away from the guidelines that are set forth by the law.
We do have a question, Allison and Julia.
Yes.
It says, when developer transfers control to the board, are all developer agreements now null and void? If so, where is the Davis-Sterling language that clarifies that?
I would not say that all agreements are null and void. That is a super broad statement to make. I think we would have to look at what the agreement is. A lot of the developer contracts and agreements are actually recorded documents. And so those documents would continue to run with the land. So I'm not sure exactly what contracts you are talking about. The other thing is that the developer often enters into contracts on behalf of the association. And so we would need to know whether the association is the signatory to that contract, or whether it was strictly a contract between the development company and the vendor.
We're going to be talking about contracts a little bit later in our presentation. And I think that was a great question, Allison. Thanks so much for answering that. I did want to point out on agendas that just as a reminder, even though we're in these times right now, you still have to post your agendas, and you have to post them where you had disclosed to your owners that you were going to post them. So if you are to post your agendas on the mailboxes or send them out via email, then you still need to do that. Remember, open session agendas are posted 4 days in advance. Executive session agendas are posted 2 days in advance.
And Big Brother is watching. So everybody
Believe me.
of that. Big Brother is watching.
Yeah.
You know, now there are a lot of legislators, as well as the California Law Review Commission, that is taking a look on how this pandemic is impacting meetings. And the question is, and I think a lot of people feel that their board meetings have actually been a little bit more productive through Zoom, because people have been able to have their information in front of them on the computer screens. And people have been able to focus more on the work that needs to get done. Nobody's traveling for these meetings. And so, you know, there is definitely the potential that the Open Meeting Act will be amended in certain regards so that people can continue to do board meetings and perhaps even elections via Zoom. And I think that if that happened, then that would be a very positive thing for our industry. It would free up the time of some of the community managers who could spend the time better than being in the car constantly. Okay, everybody knows that board action outside of a meeting is prohibited. So Wendy, you can move on to the next one.
So just as a reminder, emergency meetings are really for true emergencies only, right? And the Davis-Sterling Act refers to emergency meetings is that something that can't wait until your next meeting and could not have been anticipated at your previous meeting. So I want to be really specific about this, because let me tell you, in my years of experience, I've had boards and homeowners make requests for emergency meetings for things such as pampas grass growing in a pool area, right? You know, and believe it or not, this has happened. Homeowner violations are not an emergency unless it's a life and safety issue. Vendors not doing their job, that's not an emergency unless it's a life and safety issue. Emergencies are things that truly, truly are emergencies. For instance, pipes bursting in the association, damage done to the community, to party walls, people that have fires in their units. There's things that boards of directors really have got to pull together on to get things going right away. These are really an emergency. When you have an emergency, you don't have to give notice that you're going to be meeting. Make sure, please, that when you have your meeting, you still take your meeting minutes and that you still disclose the information in the meeting minutes of your next meeting, right? If it's an executive session item, you still have to let people know, as is required with any of your open meeting minutes, just a scenario of what happened in executive session. You do have to disclose it though to your membership. Oh, and lastly, I like the last bullet point on that. It's okay, Wendy, you don't have to go back. Oh, thank you. Email is okay with unanimous consent to make a decision by email, but this should only be done in an emergency situation, right? Now, I highly recommend that boards every year after their election, that they do one resolution that allows them to do unanimous consent for email votes. So that way you've got it on record and you don't have to try to do 2 motions via email to move a project along or to take care of an emergency. So just a little clarification, because I might be bouncing off the walls a little bit this morning. At the beginning of, as you do your annual planning with your board of directors, sign a resolution that says that you can do emergency email votes. Everybody consents to it. They all sign the resolution. It has to be by unanimous consent. And then you can do email votes for emergencies after that. And that vote does not have to be unanimous, but it does have to be a quorum of the board that approves actions being done. All right.
Okay, so executive session only. Wendy, can you roll there we go. Okay, so the law only permits certain things to be considered in executive session. I encourage you all to memorize these items because you can get into a fair amount of trouble with boards who tend to think that they can include any item under one of these 5 categories. So I talked a little bit about an issue that I had last year at our legislative review session in January, and I'm going to tell a very short story here, but it was my 2019 nightmare for sure. I was asked to step into a community and pick up a piece of litigation that had been filed. The backstory was that an association was allowing a children's sports team, sports club actually, to use a common area pool. That sports club was comprised of half members, children, and half children from outside of the community. The sports team grew and grew and grew over the years, and it became so large that different practice sessions had to be scheduled for different age groups. And by the end of last year, essentially the members could use the swimming pool about 15% of the time, 1-5, not 5-0. And what happened were the moms in the community wanted to be able to put their babies in the pool at 9 o'clock in the morning. And the kids that were getting home from school wanted to be able to jump in the swimming pool after they had finished school, and they could never get into the pool. They could access the pool at about 6 in the morning, and 9 at night, and there was a good segment of the community that was very frustrated with the pool use. And so in executive session, with a lawyer, not me, present, the board made the decision to kick the swim team off of the property. This is all in tons of public filings, so I'm not revealing anything that is confidential. The board knew that the swim team was going to be furious with this action, but I don't think that they anticipated what actually ended up happening. The swim team filed a lawsuit against the community association, sought a temporary restraining order and a permanent injunction. And after reviewing the documents, the judge basically told the association that the decision to kick the swim team off of the property was made in executive session, and therefore the decision itself was invalid. And, you know, you could loosely say, well, it had to do with litigation, but not really. The decision was made before the litigation occurred. You know, it doesn't really fall within any of these categories. And so the court was beyond angry at all of the hearings that took place, couldn't believe that the big bad community association was kicking these kids out of the pool, and it granted the injunction. And as a result of that injunction, the board is now precluded from actually going back in an open meeting and making the decision to handle the swim team. So the result was not just the fine that you would get for violating the Open Meeting Act, but it has now precluded the community from exercising its own judgment as to whether or not it's appropriate for non-members to be, you know, monopolizing the pool for 85% of the time. And the insurance carrier was also unhappy with how things proceeded. Between the litigation fees in total, both for the association and for the swim team, were over $250,000. And out of that amount, the insurance carrier only paid $50,000. So a really unthought through decision that was made improperly in an executive session cost that community an extraordinary amount of money. And of course, nobody intended that it was going to blow up into that situation, and nobody would ever think that an Open Meeting Act violation could be something so serious, but it can be. And so I just wanted to share that story with you, so maybe it will help you remember that these are the only items that can be considered in executive session, and don't try to do anything more than what's permitted.
I'm going to interject, Allison. I'm sorry. We have two questions sitting here. I'm going to address one that just came in for you, and then there's one I think for Julia's last slide. But just to end what you were currently saying, it said, so anticipation of litigation is not a permissible subject of executive session. Question.
Well, that's incorrect. Anticipation, consideration of litigation is, but the decision itself not to allow the swim team to use the pool was not a decision related to litigation. The decision may have resulted in litigation, but it wasn't a matter where the board was considering initiating its own litigation, at least not at that point.
Fantastic clarification. Thank you. And then Julia, I believe this question is for you. It says, when you say no board action, can board members discuss something without making a decision outside of a formal meeting, or can they only talk about issues at the meeting? I guess I'm wondering what board quote unquote action is.
Boards, thank you for the question. Boards are not permitted to discuss association business, a quorum of the board, outside of a board meeting. So if 3 of 5 board members are at the mailboxes and they start talking about, you know, who's on the delinquency list, that is a violation of the Open Meeting Act. So it's not just decisions, it's actually conversations. If it's not a quorum of the board, certainly you can have a conversation. But conversations with a quorum of the board, any board action or any board business cannot be discussed outside of a board meeting. A duly noticed board meeting, by the way.
Awesome. Thank you for the clarification. Allison, I'm sorry, when we do these questions, do you want me to stay on this slide or move to the next? And you're muted. You're muted, Allison.
I kind of need, I need you.
Mute. Next slide, Wendy. Thank you.
Got it.
Okay, so we talked about overuse of executive session. Just a note on emails. Again, please, community managers, set up separate email accounts for business for each of your board members. GoDaddy's got a great program. It's cheap. You can literally store emails for people, you know, going years back. So if you want to have the last 10 years of emails regarding board business saved in a GoDaddy account, it makes it really easy to obtain those emails if it becomes necessary. I tell every new litigation client that if they don't already have separate emails, they need to establish them. But I also let them know that it's going to happen. Every year that passes, it is a higher likelihood that an opposing party is going to want to go into your private emails and have the opportunity to review anything that is even remotely related to the community association. And it is easier and cheaper if you just have a separate association account.
Let's talk about what happens, Allison, if people don't follow the Open Meeting Act.
Fines, fees, and injunctions.
Moving on. So we want to talk about record inspections and inspection requests. Now, hopefully your association or your management company has in place a policy about how to respond to records requests. To be clear, records requests, when you receive them from owners, should be detailed. They should say exactly what they'd like to see. There should be a timeline of what they want to review, and they really need to have a purpose, a specific purpose for their request. So make sure that all of those three things are things that you require in order to respond to records requests. And as soon as you receive a records request, make sure that you pull your attorney into the loop, just so that you know that you're doing it. Remember that records requests they have specific time limits. And so if you receive a request for records of the association from the current year that you're in, then you have 10 business days to respond to that request. Now, 10 business days is not a lot of time if you have documents that you need to redact. And I'm going to talk about redacting information in just a moment. And that's why I believe that you need to have a policy in place so that you can respond to these requests right away. Keep in mind that people have a right to this information, and while when you receive a records request, you might kind of cringe because it's like, oh, what are they looking for? I mean, you really do have a responsibility to respond to that request respectfully and according to the Davis-Sterling Act or Civil Code 5200. Now, records requests for association records from previous 2 fiscal years, you have 30 days to respond to those. And unless it's meeting minutes, anything older than 2 years, you do not have to respond to in a records request. But you will want to send, of course, the requestor a letter saying, I'm very sorry, but we only have records for the last 2 years, and according to Civil Code, only have to provide those to you. Now, meeting minutes, you are required to provide meeting minutes within 30 days of the meeting, even if they're in draft form, so make sure you do that. And you have to hold on to and provide meeting minutes for the lifetime of the association. There is no timeline or expiration date for your meeting minutes. A great thing to do, you know, back in the olden days, we used to have a binder with all the meeting minutes in it, and I still do because I'm one of those people who likes to collect papers. Put all of those meeting minutes on a zip drive or on your cloud from every year that you have, so that you can just shoot them off when people request them. And I want to make sure that I also tell you about what not to include, right? Because it's really, really important to make sure that you know that you are not required to improve anything that could violate someone's privacy or that can possibly cause fraud. And I think Allison's going to get into that just a little bit more. But I want to just share with you a story that I recently heard. That a homeowner had asked for the architectural plans for the next door neighbor's house because there was a dispute about the building of the home. And the association manager innocently provided the plans without realizing that they should not have provided the plans for the interior design of the home. And this was already a neighbor dispute. That was a little messy. And the message that the neighbor who got the plans gave to their next door neighbor was, now I know where your children sleep. Now that, like for all of us, right? Isn't that crazy? But those are the kind of things that we really need to be mindful about when we're responding to records requests. Allison?
Okay, so the duty of confidentiality. I think that this is mostly, we have mostly community managers on the program today and not board members. So as to those managers, you have seen it happen time and time again where there's a board member that reveals some confidential information. Most of the time it's done innocently. Sometimes it's done for ulterior motives. But of course, it can be dangerous when information that is supposed to be confidential is disseminated beyond the board. It can impact owners' privacy rights. Certainly, it can impact the success of any type of litigation that you're in or other impact the advice that a lawyer gives in anticipation that that advice is going to be kept confidential. So it's just super important that the community managers ensure that the board members understand this particular responsibility. And of course, that can be accomplished with perhaps an ethics policy, which I know we don't always require signatures on, but you know, it's always good to ask for the signature if you can get it.
I think it's a good reminder too. This is something that's really important to do when you do your annual board training, to talk about the board's duty of confidentiality. It's important to know that that you have private information of homeowners, and if you even share that, you know, I've had homeowners share information with spouses who then go to Bunko and share information that shouldn't be shared. And it really is pretty serious, and it violates the rights of your homeowners, and it also violates the obligations of the board of directors. I am really a proponent for, as Allison said, having a board code of conduct in place, but I'm also a proponent for having really those tough conversations with board members who may not realize that when they're out and about and talking about things that they're actually not following their duty of confidentiality. Make sure that you're upfront about it. There are remedies, certainly for board members who just have a hard time keeping confidential information to themselves. And those remedies include, you know, first reaching out to them and saying, you know, hey, this is happening. You probably don't mean for it to happen, but we need to let you know, and please be careful. Then I would probably in your executive session have a conversation with that board member, telling the board member to that they really need to stop. And then if it continues to be a problem, then censor the board member and make sure that you put this information in your board meeting minutes, because the fact is, if anything comes out of it and the association gets sued because of a breach of confidentiality that's affected a homeowner, I'm not quite sure that your D&O policy would cover you, because you are not acting within the duties assigned to you by a board member. We're on fiduciary duty, Wendy.
Yep. Yeah, I know. My screen.
Awesome.
Do I need to go back one more, guys? I'm sorry. This is
Yes.
just, there we
Okay,
go.
there you go.
No,
Yeah.
one more. One more.
One more back. Okay, sorry,
Thanks.
people. We're having some technical issues here.
Oh, one more forward.
Okay, that's where I was. There we go.
Yeah, there we
Ah,
go.
Thanks, Wendy.
Absolutely. Thanks everyone for your patience.
So continuing with Julia's comments about member or board member duties, obviously there's also a fiduciary duty, and that the fiduciary duty will absolutely also impact whether or not you're covered if a claim is made. And so, you know, for the community managers, we all know that the board members have a duty of good faith to act in the best interests of the community, a duty of fidelity to make sure that they are acting as an ordinary, prudent board member would without taking any unnecessary risks, and a duty to inquire. You need to speak with the subject matter experts that are available to you, be they your community manager, your reserve study preparer, your you know, any specific vendor. And, you know, I think that it is helpful if when a new board is placed, that the manager, you know, maybe consider the position of the new board members vis-a-vis the association. Do they have ulterior motives for getting onto the board? Because if you are keyed into those issues before the board really starts taking action, it will be helpful to the board member that has those motives, and it will be helpful to the rest of the board to make sure that when they are acting in the best interests of the community as opposed to in the best interests of the individual director. So I have a community right now, brand new 5-person board, and there are 3 board members that are in the process of selling their homes, and they did not get onto the board because they were concerned about the future of the community. Clearly, they intend on selling their homes and dropping off the board. They've articulated that. They've been open and obvious about it. But the question is, you know, if the intent is to, in this particular case, reduce the monthly fees to increase the saleability of the home, are any of the decisions that they make that impact the budget decisions that they should really be participating in. And so having that information ahead of time before decisions are being made can help the community make sure that if there is some type of legal action later, that there will be coverage under the D&O policy. So the duty to investigate, I think, is something that is, you know, critically important, particularly for the new board members. From the community manager's perspective, make sure that the board understands what its resources really are, who can help them make the types of decisions that they need to make. You know, importantly, managers are pros at coming up with community budgets. The managers, portfolio managers in particular, who are doing so many different budgets in one year, understand the ins and the outs of every little thing that needs to be budgeted for. And if you have a board that thinks that they're going to be able to do their own budget without your participation, it's a little tough, because we all know who has the expertise. Of course, there are professional boards that do know how to do those things. But I think that, you know, with regard to budgets in particular, you want to make sure that the manager is involved. But include your lawyers in big decisions, include others. It may be your landscaper that needs to, you know, weigh in with regard to the removal of trees or things like that. But what boards really need to understand is that when the boards communicate with and involve all of their subject matter experts in making a decision, and then they make sure that that decision is made in an open meeting after a good deliberative process, that in the event that there's any type of legal action that follows that, the court is generally going to defer to the decision of the board. The court is not usually going to substitute its own judgment for the judgment of the board. There are definitely exceptions to that rule, but if the board can follow the process of consulting with the experts and deliberating in an open meeting, that is the best way to protect the board from any liability.
Allison, we have a bunch of questions coming in from a board member, Gia, who's been asking some really great questions. So I'm going to kind of fire them away so you can probably answer them in tandem. How do you censor a board member, and what does that look like? Does the board vote to ensure a member who is biased must recuse themselves, and what sort of evidence would you need to do that? And what if a board member is a real estate agent and sells homes? Would that be an automatic conflict of interest? I can.
That was a lot. That was a lot of questions.
But I know you so well, and you're just so eager to roll those off your tongue. So I just didn't know if those were. I can ask them individually, but it's really about censorship of a board member and how do you handle bias?
You know, censorship of a board member is a pretty extreme thing. And I say that because if a person was nominated and, you know, prevailed in the election and was placed on the board, they have the support of community members, and the community members, you know, should have the expectation that that person is going to be representative of their interests on the board. Of course, you know, sometimes we experience incredible voter apathy, or people voting for people that they don't know just because they don't like what the current board is doing. But censorship it's a pretty extreme thing to do. Certainly, it's a strategic decision that a board can make. But what would be better than censorship is really trying to understand you know, what the person is doing and whether it really is worthy of something that is that extreme. An alternative to doing that really is, you know, communicating with the particular person, depending on what the circumstances are. If there is some personal interest that is involved, then perhaps forming an executive committee, a litigation committee, or just getting the agreement of that particular person that certain matters are going to be handled by a committee that they're not going to be a part of. And you can conquer a lot of issues by dealing with it in that way, or trying to have, you know, a reasonable, rational discussion with that person. Obviously, there are exceptions to that, a lot of exceptions to that rule. Some people are just too out of line, and sometimes they do need to be censored, and that can be accomplished by the remainder of the board voting in executive session on that issue.
And then one of the other questions was, if there is a real estate agent on the board of directors who sells homes within the community, is that a conflict of interest?
If you're asking if it's a conflict of interest for that person to serve on the board, I would say you definitely cannot just make that determination without having a conversation about, you know, what is that person's actual financial interests in those transactions, and you know, are they making board decisions based on a benefit to them individually? If it appears that that is happening, then certainly have the conversation. But again, try to work it out without creating a negative situation. The community has to live with one another, and it would be far better to be able to work it out amicably. If the rest of the board believes and has good justification for the fact that that person is making, placing his personal interest ahead of his, the community's interest, then you could ask that board member to conflict himself out of decisions that would impact the community.
Thank you for addressing all of those, you guys. Would you like me to move on to the next slide, or are you still on this one? Sorry.
Next slide, please.
Got it.
So First Amendment issues, I don't want to get too in the weeds with this particular topic, but what I will say, and I think everybody will agree with, is boy, the coronavirus has really got out the worst in people.
Yeah.
I get a call from at least one community manager a week who is in tears because people are treating the managers so terribly during this period. And my heart goes out to everyone. So for those particular situations, both board members and community managers, unfortunately, because of the role that a person takes on as a board member, board members are considered to be limited public figures under California law, and as a result of that, you have to take a lot of the things that are being said about you. It's uncomfortable. A lot of times it gets to a level of being, unprofessional, and people can say, really awful things. But as a board member, you sort of just have to take it. Certainly, you should not be subject to any type of threats of violence or physical aggression or anything like that. But to the extent that people are not being kind to you, you really have to take it. I have seen in the last year several board members try to assert defamation claims against community members who have, said and done awful things. And from my perspective, you never win that fight, and it's an expensive fight. You can file the defamation complaint. The first thing that happens is the association member is going to hire a lawyer, and they're going to file this lawsuit. It's called an anti-SLAPP lawsuit, or anti-SLAPP response to the complaint. And the case law is pretty clear when it comes to community association board members. The defamation lawsuit will fail, and you will end up paying the other party their attorney's fees. And so, again, this is a situation where it's unfortunate, but the best way to try to work through it is to perhaps use your community manager or even another board member to try to act as an intermediary to resolve that type of problem, because filing a lawsuit over defamation for a board member is just not something that is really a great path to take.
I think one of the things that I have, what I have been told about from a lot of community managers is that people are really anxious right now, and so we are getting a higher level of phone calls and emails from people that are really just tough. As Allison said, she has community managers who are calling her weekly who are in tears because of the way they're being treated. So I think while it's really important to remember that the whole defamation of character thing is very difficult, it's always equally important to remember that, when people call you and they're yelling at you and they're calling you names and doing these things, really that's not part of your job. And it's okay to just have a policy in your company or as a board of directors that says we're not engaging, right? You don't have to listen to it. You can respectfully say, thank you for your call. Thank you for your thoughts. Feel free to call me back when it's a better time for you, or send me your concerns in writing. But don't, please don't let the stress of these times and the way that people treat you put you in a position where you feel like you just have to listen to this, or you have to be treated this way, because you certainly do not. You deserve better than that. We're all professionals, or you're volunteers. And it's okay to have a policy in place that kind of puts up a wall and says, I will not be treated this way. It's okay to do that.
Okay, we have several questions, but I'll ask them one by one. The
Okay.
first one is, what are your thoughts on an anti-harassment policy to protect management and volunteers?
Excellent. It's an excellent idea.
Mhm.
And I've actually got those policies in place with a good percentage of my communities.
Mhm. Yeah, I've
Also
seen them.
can
I've
be
seen them in
done-
governing documents as well.
Yeah, it can also be done in the context of, you know, the document that we generate is a nuisance and harassment policy that can be, you know, applied both as between owners as well as between board members and owners.
Great. What about attacks on board member by another board member? And then I have one more question.
I'm not sure I understand the question about attacks on board members. What is? Can you read that question again?
Yeah, so simply like how do you addressing board members attacking one another as opposed to a homeowner attacking a board member, but like board members going after their fellow board members?
You'll love this answer. They're supposed to be doing business at open meetings. And so if the email traffic is becoming overwhelming, if, you know, if a board member is knocking on your door and you're a board member, let them know that the business will be conducted at the board meeting and that you're not going to engage with them in between board meetings. You've got to try to work together at the board meetings, but really there's no need to talk in between board meetings.
And I always like to say in board meetings when there's unrest and there's that conflict between board members, that takes you away from doing the business of the board. My standard has always been, and I actually learned this from a great mentor that I had many years ago. I mean, she used to say, this is not the way a multi-million-dollar corporation behaves at a board meeting. You would never see the board members of Coca-Cola doing this, or, you know, or any of those other big companies, and that's not how you should do it. You are fiduciaries for a multi-million-dollar corporation, and you should behave as such. And I found a lot of times that kind of brings down the mood in the room and gets everybody on the same level. And then after that, if that just continues to happen, then sometimes you just got to adjourn the meeting, right? Because you're not getting any business done. And so that would be very unfortunate. And I'll have to say it hasn't happened very often in my career. So, you know, hopefully you don't see that very often either.
Awesome. This one's a backing up question, Allison, to something you talked about with board member emails. Jennifer Richardson said that they recommend board members get a separate email already, but they rarely do. So are you suggesting that managers create and assign emails for them to use exclusively for HOA communication?
So I don't want to plug the GoDaddy again, but I'm going to. if the association has a GoDaddy account for the board members, then when you become a board member, you will be given that, you know, GoDaddy email address, and you can have the cost associated with that, you know, as an item in your operating budget. You know, it's better if the association controls the email account. If that isn't being done and they have separate emails, that's good, but that's not the best solution. Of course, the worst is to not have the association only email account.
Right. I remember discovery. Now, and mind you, board emails are not something that people can request. Like, it's not like a records request. It really is a discoverable in a lawsuit kind of thing. But I had a board member who felt very violated because she had gone through her parents being very ill and had, you know, there was a lot of emails in her inbox, or that she had responded to, kind of were mixed. Like, hey, I just can't deal with this association stuff right now because I'm dealing with, you know, this with my family. Well, that's discoverable, and it felt like a real violation to her. So it's a great example of why we should just do board business on a board email and leave your personal email to yourself, so that, you know, if ever your emails are subpoenaed, that you are not sharing all of your personal information with those who are going through your emails looking for evidence.
Okay, and one more question before I go to the next slide. How do you deal with majority board members who gang up on the minority group along with the management company and hired attorney? They're discriminating, condescending behavior, and a negative discrimination on a kind of negative discrimination on minority group.
Wow.
I'm just going to say that I think that I know what community this question is actually coming from. And so I'll start with that. But there is a difference between bullying and board members making legal decisions at board meetings. And so it happens all the time that you have a 5-person board that talks about an issue, and you have 3 members that support one position and 2 members that support a different position. And every board member is entitled to their opinion, so long as it's not being made for a self-interested reason. And so that's what deliberations are for, is so that the boards can have a discussion about a particular issue and weigh the pros and cons of each of the decisions that need to be made, and then vote. And, you know, you're not always all going to agree, but the fact that you've got a 3 against 2 situation does not constitute bullying. That's my point. My second point is this: discrimination is an awful word. No community manager wants discrimination in their community. No lawyer, no, educated board member wants discrimination in their communities. When you use the word discrimination, you are triggering a fair housing claim, and you are putting your community in a situation where the community, the board, is going to have to conduct a fair housing investigation. So I encourage people to be very specific with the language that they are using. Just because you may be a member of a protected class, that does not mean that a decision that is being made because you are a member of that class. And so again, discrimination it's a very loaded word. And unless you really have some evidence that decisions are being made because of somebody's status in a protected class, that is not a good word to be just throwing around. Now, Julia, I don't know if you have other points on that.
No, you just packaged that up beautifully. That's absolutely right.
Awesome. Thanks, guys. We're going to move to the next slide.
And speaking of fair housing.
Yes. Yes, go ahead, Julia.
So I have to tell you that, you all can see, and Allison is just wonderful, but fair housing is her gig. Man, she loves fair housing. As a matter of fact, Allison is the chair of the Housing Task Force for CLAC, and her knowledge of this subject is incredible. So look at that list of fair housing issues. These are all of the things that we see through fair housing lawsuits, and all the things that we have to be really, really careful about. So Allison is going to dig in a little bit deeper about fair housing, the things that you should look for, the processes that you should have in place, and then the remedies if there are many violations of fair housing.
Yeah, so every year they add new categories of people to the fair housing laws. The protections that are afforded by the federal fair housing laws are not identical to the protections that are offered, or the classes that are protected under the state laws. And so, we can talk about fair housing issues in some pretty broad strokes, which is enough. But it's complicated. And Wendy, can you hit the next slide, please? fair housing is extraordinarily important for everyone, absolutely. Unfortunately, though, the fair housing laws really place a undue burden on community associations in certain regards, not in all regards, but in certain regards. You know, this is one of a very small group of issues that my response to every time is please call your lawyer, because not handling something that doesn't seem like a big deal can very easily turn into a six-figure fine that the association has to pay. So I think that with regard to the fair housing laws, as we work with CLAC and in our state legislature, we say all the time that we think that the people that are writing the laws don't entirely understand what a community association does and the role that it plays in the community's operations and lives, and what it knows about the people that actually live in the community. So the federal legislation in particular has placed a pretty significant burden on community associations. If a association either perceives that there is discriminatory conduct that's taking place within the community, or it receives information suggesting that, or if it actually receives correspondence that says I'm being discriminated against, you don't really have a choice. You need to call your lawyer. Do not pass go, do not collect $200. Mm-hmm. The risk to the association is just too great. I think everybody can agree that an association should not engage in discriminatory conduct, and that if an association does, then the association is going to have to accept the risk of engaging in that conduct. But what happens when a management company's employees, and this is a personal situation that I've been involved in, great management company, I love the management company, they have great managers, and takes a phone call and is talking to an owner who is complaining that their child was almost hit by a car in the streetways within the community. And the manager's response is, ma'am, we appreciate the information, we'll follow up with the driver, but it's not safe for your child to be riding a skateboard inside that part of the community. The streets are too narrow. That sounds like a totally appropriate response for the community manager to make, and it was only made, on behalf of the safety and welfare of the child, and trying to prevent any type of awful occurrence from happening, inside the community. Would you ever think that that is a discriminatory conduct, that's a discriminatory conduct or language? And, normal people would say, no, safety is important. But the mother of that child might think that their child is being discriminated against based on their age. And so community associations don't always know and are not always able to identify what a third party is going to consider discriminatory conduct. But the fact remains that if an association knew or should have known about discrimination, then it has to take language, it has to take action. And then sometimes you have a situation where it's two neighbors who are fighting against one another, each of those neighbors being members of a protected class, each of those neighbors going to the association and assuming that the association is going to be able to handle that particular situation and address a neighbor-to-neighbor conflict in the context of the fair housing laws. And so there are, there is a specific practice that has to be employed whether the association is directly involved, minimally involved, or not involved at all. The law requires that the association take action, conduct an investigation, and appropriately handle the situation. Turning to what the investigation is, who the hell knows, because it's not defined. And what I don't think the legislators particularly appreciate is that there is only so much that a community association can do. We do not have the ability to just evict people from our communities. And so if we believe that that discriminatory conduct has occurred, the association can file its own fair housing complaint and escalate the issue into a situation where the association might have to end up paying a fine. It can decide that it's going to try to handle the situation through a notice, a violation of the nuisance provisions, and scheduling a hearing so that people can participate. But they're all bad choices. And that's really the problem, is you want to do what's right, but it's hard to know exactly what's right. And you're asking boards and community managers to make decisions about, things that are complicated for lawyers to deal with.
Mm-hmm. Right, discipline and enforcement. We're just going to kind of quickly go over discipline and enforcement. As a reminder, when somebody violates your governing documents and you need to reach out to them, remember that your notice of violation, really, you have a due diligence to provide information that provides a homeowner with the most information they can have to rectify a violation, right? That's called due process. And you can't deny homeowners of their due process. So you send out your notice of violation, and your notice of violation should have exactly what is wrong with the homeowner's property, what CCNR or other rule that they have violated. Make sure you're very descriptive. You can't just say a bush in your front yard needs to be trimmed. You have to probably include a picture and exactly where the bush is. That's part of due process. And that you, again, say exactly in your governing documents what they have violated. Make sure that you've given them a remedy and that you tell them what the next step is if they don't take care of that violation. Notice of a hearing. You can send a notice of a hearing 10 days in advance of the hearing date. Most of the time, from my experience, homeowners think, 10 days is not enough. It's okay to show a little grace and extend that a little bit. A lot of times, boards of directors will have a policy in place separate from 10 days. That'll say 15 days or 20 days because it's more convenient for the board. California law says 10 days. When you call a homeowner to a hearing, then it's always a very respectful thing. I really like the idea of greeting homeowners when they walk in the door, kind of getting everybody on the same level, getting rid of that anxiety, and then having a conversation about the reason that the homeowner has violated the governing documents. Sometimes they have a really, really good excuse why they're parking on the street. They have a caregiver coming in to take care of a sick relative, things like that. So make sure that you're open to those conversations. When you're done with hearing with the homeowner, then excuse them politely and let them know that the board will deliberate and decide the best way to move forward. If fines are involved, or actually any deliberation that's involved, you go ahead and you send a notice out to that homeowner. Civil Code says that that notice has to go out 15 days after you have had the hearing. So make sure that you provide that information and so that they have that information. Remember, fines are not an income source, right? We don't want to collect fines as an income. What we really want is compliance. We want our communities to be beautiful and for everybody to kind of abide by the governing documents. And so any policies and procedures that you have in place to kind of address violations in a way that helps people understand what they've done and then helps them understand the remedy of that is a better option than just calling homeowners in and fining them and moving forward that way. So I think I already said this. Remember that fines aren't an income stream. And I've told you how to impose fines. You have to be very careful about the amounts. They have to be reasonable. Fine schedules are required. So you should, in advance, let homeowners know what the fines could possibly be. Suspending common area privileges. It's really interesting, right? Because we know that you can't suspend like remotes to get into gates. People are allowed to get access to their homes. But you can suspend people from using the pool, although that's not really applicable right now, or community rooms or things like that. You do have a right to entry. It's not defined in the Davis-Sterling Act, but it should be defined in your CC&Rs. If a homeowner refuses to mow their front lawn, for instance, and it's become a nuisance, after due diligence and notifying the homeowner, associations have a right to go onto the property and mow the lawn, or hire somebody to make sure that the lawn is being mowed. That's just an example. And then to charge the homeowner for the cost of doing that, which is an enforcement assessment. Now, the one thing that we probably all know from SB 323, right? Can I still suspend an owner's right to vote? Is everybody shaking their head no? No, you cannot. Every owner gets to vote. You don't get to suspend anyone's rights to vote anymore. Even if they haven't paid their assessments, they get to vote. So another good reason to stay on top of what's happening in legislation these days. And I'm just kind of running through these because I know we're running short on time and I want to be respectful of your schedules. And so please, if you have questions, go ahead and type in the chat and we'll get to them.
So IDR and ADR, I just encourage the community managers to double check the CC&Rs and see if there is an IDR requirement. I know that, the general practice is to move through the notice and violation and hearing process and try to get it resolved that way. And absolutely, that's the best way to do it. But if you do have an IDR requirement, you need to make sure that you're complying with that requirement before you get into ADR. And you never know. I know that most of the time you think there's no way we're going to be able to resolve this issue after the hearing has taken place and fines have been imposed. But people don't want to spend their time engaging in these types of battles. And so if a quiet conversation between a board member and a community member will resolve the issue, excellent, we should try it. And then as far as ADR is concerned, people want to participate in ADR until they find out that they've got to pay for half of it. And so we find that once we send out the right to resolution and they contact us back and say, yes, we want to participate in ADR, and then you propose to them who the mediator could be and what their fee is. There's a lot of backing out at that point. And so it's good to let them know up front in that request for a resolution that there is a cost associated with the ADR.
I know we're running short on time, but I wanted to ask a quick question. It's a great question. Can you, I think I know the answer, but I think it's important. Can you enter a home to correct a violation without the owner's permission?
I don't know that you would, oh, go ahead, Allison, I'm sorry.
Well, I just was going to say that the right of entry is usually a right that's contained in the documents, in the CC&Rs, and there will be a process that is set forth in the documents. I wouldn't recommend entering somebody's over their objection. But sometimes the issue is that you're not hearing back from the owner. And if it is a critical issue that needs to be resolved and the owner has not said no, then you might want to do it. If you truly need to get into the home over the owner's objection, then you can obtain a court order that allows you to get in. But that's expensive, and so you don't do it unless you need to do it.
And it's really extreme, right? I mean, I can see entering a homeowner's home in case of an emergency, if there is a pipe that's burst in the wall and you can't get a hold of the homeowner. But I'm not sure that there are really any violations that would take place within the home that you really could tie into being an emergency. The only thing that comes to mind is, and it's not an emergency, by the way, But if you have the wrong color of window coverings up, you know, you don't get to enter the home to change the window coverings. You have to be reasonable. Other than that, when we talk about entry into homes, we really talk about entry into properties. It really is about maybe weed abatement is a big thing up in my area, up in the Auburn area. People who don't take care of their lots or don't take care of their the back, you know, acre of their property. But typically we don't see entering into a home as something that you'd see in a condominium association, again, unless it's an emergency.
Sorry, Allison, I'm trying to manage the chat and the PowerPoint. Just curious, do you want the next slide or this one?
Next slide. Yes, sure. So just quickly on this point, the law does not require that you engage in ADR before filing a complaint in every circumstance. You only have to go through the ADR procedure for certain categories of cases. But what I would say is you're going to spend a lot of money filing a complaint and litigating a case. And so I would encourage everybody to try ADR. If they are actually going to proceed with litigation, do ADR first. It makes sense financially. Okay, do I have a right to file a lawsuit? You know, very vague question that I wrote, but usually the answer is yes. But you would want to consult with your lawyer to make sure, you know, what you're entitled to do under your governing documents. If you did not comply with the appropriate procedure of sending a violation notice, calling an owner to a hearing, and sending out some type of letter of determination following the hearing, do not file a lawsuit. The judge will come down on you so quickly, not complying with your own procedures. So when somebody brings an enforcement action to me, I want all of the letters. I want to make sure that they complied with everything that's required by their governing documents. And if they haven't done it, I make them back up before we get into court, because there's just no real excuse for not doing what your documents require, particularly in a case where you're suing somebody for not complying with the documents. And if you do the procedure correctly, then in enforcement cases, you are entitled to get your attorney's fees and costs back.
Contract provisions. Contract provisions they're more serious than you might think. I have had boards of directors and community managers who have tried to pin their own contracts, or think that because they have experience in one field that their experience translates to another field for contracts. And boy, that is just not the case. We really have to be very, very careful about how we handle contracts, the things that are in them and the things that are not in them. Frankly, as a community professional, I wouldn't know what I was doing in writing a contract. And I'm not sure very many community professionals do, or board members, quite frankly. It's very important to use your experts appropriately. Do you need to hire a lawyer every time that you want to write a contract? Well, it depends. And I say that because I know homeowners associations, particularly really, really large ones, who will have a general counsel who will write a template for a contract. And as long as you don't go outside of the guidelines of that template, don't change anything at all, and you're just filling in the blanks, then you're okay. But generally, yes, every contract should be reviewed by the association's attorney prior to signing it.
So for contracts, we want to make sure that everything is in writing. We want to make sure that the contract requires proof of insurance, not that the contract requires insurance, but it requires proof of insurance. We want it to specify independent contractor status, which everybody knows there's a big case came out last year that, you know, dramatically impacts that. And so if it's a contractor that's on your property often, then you definitely should be consulting with your lawyer to make sure that the contract for that particular party is very specific. You should always include defense, indemnity, and hold harmless provisions, and you should make sure that they run to the association's benefit. Having those provisions in a contract and having them run to somebody else's benefit does not help you.
Yeah, not really one of those things. We don't want to. We don't want to negotiate subrogation or indemnification, right?
Yeah, and
I mean, they're just
if you can't tell which way the provisions run, then there's a problem. That should alert you that something is wrong.
Yeah, and one more thing about this always having written contracts. I think in my experience, sometimes you'll get a proposal from a contractor and they'll just say sign here, right? Just sign the proposal and that'll be our written contract. Allison, what do you think about that?
I don't personally like it. I prefer extended contracts, but look, well, there's a lot of things that you would have in a contract that you are not seeing in that proposal. I can't tell you how many one-page proposals don't include warranties. That's a basic thing that you should be getting in your contracts, and no warranty on a proposal most of the time.
Or things, even things like gross negligence, liability, things that to the maybe somebody who is unfamiliar would not even realize wasn't in there, right? Because it's a proposal, and typically a proposal, respectfully, is has provisions in it that benefit the person who has provided the proposal, and so again, very important to have a contract in place and to have your attorney review it.
Okay, construction contracts. You have to make sure that the contractor is licensed. It's very easy. You go on the contractor state license board. The proposal or contract that is provided will have their license number on it. You can check it. It takes 2 minutes, but you've got to do it. It's the first thing that I do every time I get a contract for review. You do want to review the scope of work under the construction contract. So if you are about to enter into a contract that is for a fair dollar amount, you want to make sure that somebody that understands the construction project is reviewing the scope of work. It is as important that that scope is correct as it is that the rest of the contract is correct. You should always specify what constitutes the contract documents. There are general provisions that are stuck in every single construction contract that says, any plans that apply to the property are part of the contract, or any exhibits that are attached to this document are part of the contract. And 9 times out of 10, there's an amazing set of plans that contradict one another. And so you do not specifically know what plans are part of the contract. And half the time the exhibits don't get circulated. And so somebody needs to make sure that the contract documents are correctly specified with dates in them in the body of the contract. It is also always best if you can get the contractor to obtain the permits for you. For any construction job, the owner usually has to pay for the permits, but let the contractor get the permits. The contractor has way more experience dealing with building officials than the association's representative would. Contractors that work with building departments over and over again can walk in and know who the person is on the other side of the desk. And that relationship always helps make the project move more smoothly. And then also, again, you are entitled to a warranty in your construction contracts. Make sure that you've got a warranty in there, and make sure that that warranty is consistent with the applicable law.
I really appreciated Reagan Brown said California State License Board is a great resource for information regarding contractors' history, and it really is. So before you go into contract with someone, make sure that you kind of do a little bit of research, right? There's a lot of wonderful, highly qualified contractors in our industry that we have great relationships with. Those that you're unfamiliar with, please do your research. Contracts. So just some, a little bit more information. Please never sign a contract with blank lines. If you get a contract and they say, we'll fill in the dots later, no, thank you. Never sign a contract with blank lines. Never ignore contract deadlines. Even if you have an agreement that things are going to maybe take longer than is outlined in the contract, get a change order. Have something in writing that says contract deadlines are being extended. Never agree to advances not required by the contract. The contractor comes back to you and says, we need, you know, $10,000 more because of this. Go back to your attorney, or just have a conversation with a contractor that says, I'm sorry, that's not part of the contract, right? Everything we do, we want to make sure is within the written contract so that we're complying to it, and so that everybody knows exactly what's supposed to be happening. Don't agree to limitations and liability. Again, refer to your attorney. Your association governing documents probably have information about what kind of liability the association should have. Your contract should have the kind of liability that the contractor is going to have as far as coverage goes, and your attorney should be the person who says that's adequate or not adequate. And then never agree to shorten statutes of limitations, right? Really honor your community by having that length of statute of limitations. Is a reason why it's in place. And that's because you need time to kind of figure out what's happened, do any research that needs to happen, have inspections done, investigate where you're at. And so if you need 5 years or 10 years to do that, then don't let somebody talk you out of the amount of time that you're allowed by law to have.
Okay, insurance coverage. So, you know, when you receive a complaint, sometimes it's obvious who to tender to. If it is not obvious to you, send the complaint to your lawyer. The lawyer can read the complaint and tell you whether it needs to go to your general liability carrier, your D&O carrier, or both. The half an hour to hour that the attorney spends on providing you that advice is golden. You have got to tender the claim to the right carrier, and you've got to do it at the right time. Remember that D&O, that the tender of the claim to the D&O carrier and the tender of the claim to a general liability carrier, they trigger different defense and indemnity obligations. And if you are not an insurance professional, trying to make that decision on your own is difficult, and you don't want to compromise the association's right to obtain those defense and indemnity obligations by either not tendering to the right carrier or by tendering too late. So once you receive that complaint, this is something that should kind of move to the top of your list. You want to tender if you are not getting a response back from the carriers every single week. Send another letter, even if it's just a follow-up. I tendered this, I don't have a response. They have obligations and timelines that they are supposed to be responding in. And when they don't do that, that typically means that there's a problem. And we want to identify what the problem is so that we can get the carrier on board as quickly as possible to help defray the costs of any legal action.
I think Terry Guest had a really good suggestion, and we didn't hit on it, which is make sure that any contract that you enter into, that the association is listed as an additional insured. It's really important to make sure that that you have a copy of that certificate of insurance, right, Terry? And that the association is listed as additional insured for anybody that's doing business on behalf of the association. Oh, endorsement. Terry says endorsement is better than the certificate. Just make sure you're additional insured.
Okay, so I think last slide on this particular, on insurance coverage is just that there is a difference between the duty to defend and the duty to indemnify. If you have coverage under a general liability policy, the carrier should be paying both for the association's defense, plus it should be paying for any damages that result from whatever the liability arose out of. D&O policies are not the same. You have got to understand the content of your D&O policy. They will almost always pick up the defense, but they certainly do not always indemnify the complaining party for the loss. And that is something that the board should understand right away. So have the attorney review the D&O policy, have the attorney speak with the board, because if there is a real liability there, you may need to start budgeting for what that liability is, depending on the language in the insurance policy.
Well, this is our last slide, and I'm going to take this one. How to interact with your attorney. So I, last year, the middle of the year, about this time of year, I did this kind of tour where I went with a lot of different attorneys in their offices and kind of picked their brains about what we can do as community managers to be better partners with our attorneys. And I got some really great feedback. So I'm going to share that as we go through this slide. Let's start first with communication. So for communication with most associations, either the community manager or the president is the contact with the attorney. Make sure that you know who is contacting the attorney about what items. Have permission from your board of directors to be contacting the attorney, because there's cost involved in it, but it's a very, very important thing that you do. So make sure there's a protocol in place. By identifying who is going to be speaking with the attorney, it really helps to eliminate confusion, and it helps to eliminate redundancy, right? So community manager or board president should be the ones who are communicating with the attorney. If you get more people involved in that, then it just becomes a lot more confusing. If anybody else is going to be involved, again, get permission from the board of directors. Emails and phone calls. It's always great to email your attorney so that you have your request in writing, your question, anything that you need. I always recommend that you start though with a phone call to say, I'm going to be emailing you, and here's what I'm emailing you about. It opens a dialogue with that attorney so that they can ask questions about the particular subject. And it's just a great way to kind of start the conversation and for them to gather all of the details that they need to provide the information that you need to either forward to your board of directors or for you as a board member to discuss. Remember that lawyers are the ones who go to court, right? And so it's important for them to have every single detail about what's happened. The survey that I did with the attorneys, one of the things that they said was a little point of frustration, if you will, and that's my word, is that they get a request for information for documentation and for advice. And then the attorney digs in and they do all of the research and they provide the advice to the community manager or the board of directors. And then, a week before the meeting when they're putting the board packet together, the community manager or the board of directors say, we forgot to tell you this important element of it. We forgot to do this. We forgot to send out notice of violation, or we didn't call the people to a hearing, or we've already done this part of research, and it completely changes the advice that the attorney would give. So making that phone call ahead of time is really important to be able to really give the attorney everything that they need. Provide complete documentation, please. If you've got meeting minutes that talk about what you want your attorney to provide you advice on, forward those meeting minutes to the attorney. If you have letters that you've written, if there is any correspondence whatsoever or anything that will help the attorney form an opinion based on all of the work that you've already done, it's really important to get that ahead of time. And then understand what emergencies are, right? So emergencies aren't that you have waited until the last minute to ask for advice. Emergencies are that something has happened that needs immediate response, and you need the attorney to respond to it immediately. Not because we have failed to be organized or to have all of our task list done in advance of our meeting, but because something truly has happened, that is an emergency and that needs an immediate response. I hope that makes sense. Thank you for joining us. We hope you found our presentation to be helpful. We know there's a lot of information, and we appreciate your time.
Thank you, guys. I'm gonna get Jennifer to come back on here really quick. Thank you for stop sharing, Wendy. Is my headphone working? Can you hear me?
I can hear you.
Okay. Freaking out for a second. I'm like,
I tried to start my own video and it wouldn't let me.
I know, sorry, I had to ask you.
That's okay. Julia and Allison, wow, what an amazing, amazing presentation. You guys gave so much information. I'm so glad this is going to be available on video later so I can go back and get more notes.
A lot.
So thank you, ladies, so much. You did a wonderful job.
Thank you.
Upcoming programs, you guys, we have our virtual legislative day coming up on August 12th. It's from 1:30 to 3 o'clock. It is going to be on Zoom. This is kind of taking the place of our ledge days that we didn't get to do in person. I know that the committee's been working really hard on getting this together and getting some representatives available for us to speak with. And I know Julia touched during the presentation a little bit about keeping up on what our legislation is doing. And this is really important that we be involved and have our voices heard. So I hope everybody attends that. And I believe Rachel will probably be sending something out for us to join when it gets closer.
It's
Also,
live.
Oh.
You're already registered.
The Zoom link though, I mean to.
Oh, yeah.
Yeah. We have our next digital education program is scheduled for August 27th, right here, same bat channel. It's at 11:30 on Zoom. It is the balcony collapse from 2015 and the California legislative response to that. It's going to be presented by Richard Avalar and Associates. And then I'm going off script a little bit here because Rachel didn't give me this, but one more event we have coming up, and I'm super excited about it, is our groundbreaking statewide virtual event for our legal forum this year. This is going to be amazing, you guys. This has never been done before. All 8 California chapters are participating in this to network, learn, get education, continuing educational credits. PCAM credits will be available for this. So this is super exciting. I've had a little sneak peek into what's happening and I'm so excited. I can't wait for this. So save the dates. That is going to be September 15th through the 17th, and be prepared to explore and discover. Thanks again, you guys, for attending today, and hang around for our networking session.
Is there a clack drawing?
No clack drawing or anything today.
Okay. All right. Great.
But thank you for asking. And Julia Souza is the chair for that statewide legal forum. So if you have questions, pick her line now. She's here.
I'm so excited. Oh my goodness. This is really going to be so cool. I mean, well, first off, Rachel is the mastermind, right? So she's a creative genius, and what she's putting together is amazing. So it's going to be totally cool. I can't wait to, it's going to be like, you know, peeling an onion, right? All of the layers to it, but it'll smell really good.
Lots of raffle prizes and
oh my gosh,
events, and you're gonna get mailed something in the mail. I love getting mail nowadays.
Yeah,
like, oh
we're gonna have a live concert, right? I mean, there's some really cool things that are gonna be happening. So exciting stuff. Yeah.
Yeah. All right. Well, thank you guys both so much. We really appreciate it. This will be available on YouTube within like the day or so. I will email out the link to the YouTube for this, as well as the PowerPoint PDF to everyone who was here today. We really appreciate you. If you want to come on and say hi now, you're more than welcome to turn on your video and say hi.